Good evening, everybody out there in the virtual world, and welcome to tonight's webinar put on by the ECU Medical and Health Sciences Foundation. And the webinar is titled, If There's a Will, There's a Way, How to Optimize Your Financial Planning in a Post-Pandemic World. I want to start by giving the behind the scenes crews a lot of credit. These things don't just happen. There's actually a lot of production that takes place behind the scenes. So Natasha Parrish, Grace Tolson, Nicole Stokes, and Jessica Nottingham, thank y'all so much for working and to get this thing put together. A few quick ground rules and format information. You're obviously in a webinar on Zoom, and right now everyone's microphone is muted, and we appreciate that. And we're going to ask that you keep your microphone muted. It's set up for a two-way communication, however, but we're going to record this, both the live presentation and what's going on in the chat. So just please keep that in mind. Stay muted during the presentation from Kinna Clark and Greg Abiunis. However, if at any time during the presentation you want to go ahead and type a question into the chat, feel free to do that. All the chat messages will be able to be seen by everyone participating in tonight's event. After Kinna and Greg complete their presentations, and they'll be doing a little back and forth, we're going to open up the chat. We're going to go over the questions that are in the chat, and we'll also open it up so if you just want to ask a question live, and don't be shy and be prepared to unmute your microphone. So thank you so much for attending tonight and for your patience and understanding. We are so fortunate to have two of the world's experts in plan giving and wills and advancement work and development with us tonight. And they're both ECU graduates, of whom we're very proud. First, I'm going to introduce Greg Abiunis. So Greg is from Wilson. He went to school, of course, there at Barton College, Wilson's own, and then came to Greenville as fast as he could, where he got a master's degree in exercise and sports science, sports management. He fills some big shoes here. In Greenville, he's the Senior Associate Vice Chancellor for Development at the university. And we're very delighted that we have a great partnership with Greg, and he's doing some wonderful things to help us improve our planned giving at the foundation. I'm especially happy to welcome Kinna Clark, an alumnus, back to the university. Kinna got her undergraduate degree in business administration from East Carolina University, and then she went over to North Carolina Central, where she graduated from law school, stayed at Central, where she served as a major and planned gifts officer, and then was captured by the UNC system office. We like the UNC system office a lot because that's where all our funds and direction and guidance comes from. And so we're thrilled that we have one of our own there. And I want to show you something that I was happy to see. And Kinna didn't know I was going to show this, but Jessica and Greg, they put out this great thing here called the Navigator, Your Guide to Planned Giving. And in the spring of 2020, it featured Kinna Clark. And you know that she cares about the university, and that she's not anywhere close to probably needing a will or anything like that. But she's already established a planned gift called the Kinna N. Clark College of Business Scholarship Endowment. And it just shows that it's not too early to start thinking about your will, your planned giving, and how you go about doing that. So we're thrilled to have Greg and Kinna with us tonight, and Kinna's going to start us off. So without further ado, Kinna, thanks a lot.
Absolutely. Thank you so much, Dr. Garrison. I truly did not know he was going to show the Navigator, but I appreciate your kind words, and I do agree. You're never too young to start thinking about your estate plan. Everyone has an estate, so, and of course that's what we're going to talk about tonight. So Thank you again, Dr. Garrison, and welcome, and thank you all for being here with us this evening. For our session, of course, if there's a will, there's a way. We are happy to present to you all tonight. And so tonight, Greg and I will discuss the importance of having an estate plan during and post-pandemic, benefits to having a will in place, some options for charitable giving through your estate plan, along with a few great gift opportunities due to the Secure Act's elimination of the stretch IRA and even historic low interest rates. And so as Dr. Garrison mentioned, we will have some Q&A time at the end as well. And so with that said, before I actually start our first slide, I kind of just wanted to start us with a question. And so that question is, why is this important, right? Why are we having this session? And so when you think about when a loved one passes away, it's already a difficult time for family, and we don't want to add to that by not having a plan in place for our loved ones to follow. When someone passes away without a will or an estate plan, it leaves a lot of questions unanswered for the family and makes the estate follow the state's intestate succession rules, which may not be the way you would want to distribute your estate. It can be burdensome on your loved ones, and your wishes may not be fulfilled. I've had a loved one pass away without a plan, and trying to process my loss while also being faced with figuring out what he would want, the who, the what, the where, right? It made for an even more trying time. And so we want to eliminate or at least limit that confusion or issues between family members, or even just, like I said before, making sure your wishes are fulfilled while also making sure your state doesn't have any tax issues. And so with that said, I will start us off with the second question. And so that is, did you know that most people do not have a will? Some of the most recent surveys have indicated that approximately 6 to 7 out of 10 persons actually pass away without a will. These 6 to 7 persons on this graphic may be family, friends, and neighbors, and yet they do not have a plan for their estate. And so we don't want you to be one of those 6 or 7. So put your plan in place, don't procrastinate. And so whether we are in a pandemic or post-pandemic world, it's extremely important to have an estate plan. There are several events that should encourage one to review an estate plan, of course, outside of what I just mentioned, right? So for example, a family member might be added or a person might pass away. Assets continually change. The estate may have increased in value, or a major investment asset might have been sold. There are also regular major tax law changes that could impact your estate and your plans. And so many experts recommend reviewing your plans at least every 4 years because of the ever-changing family dynamics, health and financial pictures, goals, and laws. You have worked hard to save, to conserve your estate, and to invest and make it grow. And so with all this time and effort expended to acquire and build your estate, it makes the best sense to plan for eventual distribution. The planning process can achieve very favorable results for your family as well as your charities of choice, like our institution, ECU. And with an update plan in place, you can say what happens to that estate that you have worked to build. And so with that, when thinking of your plan, excuse me, it is important to organize your goals, especially your financial future goals. And so most individuals have fairly similar general goals. You would like your estate to be distributed according to your wishes and not the wishes of the state legislature. It is desirable, of course, to minimize attorney fees and court costs and even avoid unnecessary delays. Some may want to avoid federal and state estate taxes because you want more to go to your loved ones or your charities of choice, those charities that, of course, are near and dear to you. And so finally, it would be desirable to have even privacy and a quiet process in place. So when thinking of your goals and building your estate plan, it's also important for you to think about your living will. The main difference between a living will and last will is their function. You should think about including both in your plan. While a last will directs the distribution of assets after a person's death, a living will gives directions regarding the medical care of someone who is still alive though unable to communicate their wishes. While not everyone is required to have a living will, many persons are using these directives to cover those possible needs of a person who is potentially terminal, has a potential terminal condition. The will should conform to statutes, of course, and many states have different requirements. They typically cover circumstances such as persisting vegetative states and even discuss various types of care, including both nutrition and hydration. And sometimes together with the living will is a durable power of attorney for healthcare. The durable power of attorney for healthcare is applicable in a much broader range of circumstances, since the living will is usually intended to apply only to the final condition of a person. The durable power of attorney may apply in many different circumstances, and whoever has been selected as holder of that power will be able to make many healthcare decisions for the individual. And once again, even with that, you want to make sure that that instrument is properly signed and witnessed as required by state law. And so there are many advantages for people that do have a will in place. And so first, you're able to specify the distribution. You can give away, give any amounts or percentages to persons and or charities that you pick rather than depending on the state statute to allocate or distribute any manner that you might find totally unacceptable. Second, you nominate the guardian. If you have minor children, I'm sure you would far prefer to pick for yourself the most important person who will be entrusted with the care and upbringing of those loved ones, rather than have the state judge select that guardian on your behalf. Third, you choose the executor, a personal representative. He or she has a great deal of power and authority. They'll be in charge of managing estate, paying all the bills, and making the final distribution under your plan. You want to make sure you have selected someone who will do a good job and see that the plan is properly carried out. And fourth, you can create trust. There are many reasons to create trust. Some family members would be far better to receive distributions of income rather than a lump sum principal amount. You can make provisions for these family members in a way that is most helpful to them in a trust. And then finally, you can make transfers to charity. The gifts of charity could serve as a legacy or a remembrance to your involvement and support of those charities during your lifetime, like our alma mater, of course. And you can also utilize trust for charitable gifts as well. And so with an estate plan that includes a will, you have that ability to make bequests to family members and or charities, as I mentioned. There's great flexibility with the bequest provision and can be made in several different ways. You should give some careful thought to these different methods because a good plan will frequently involve a combination of bequests. First, you can bequeath a fixed amount. For example, you could give a fixed dollar amount to an individual. Second, you can bequeath specific property. There may be some assets that have importance to you or some sentimental value, and you want to select personally the individual to receive that property. A bequest of specific property entitles that person to receive that exact asset. And after the fixed amounts or specific bequest, the balance of the estate is returned to the residuary. Ordinarily, your residuary is divided on a percentage basis, and you will then make distribution to persons or organizations according to that percentage. One bit of advice I always like to point out is there are times where estate plans distributed more or less than 100% of that estate, and this can cause quite a confusion. So I suggest in your documents, you always give away exactly 100% of your residuary, no more and no less. And finally, you might consider a contingent bequest. If some family members or perhaps all family members pass away, then it may be appropriate to remember other family members or a charity with a contingent bequest. This takes effect only if the other persons are not living when you pass away. And ultimately, the beauty of a bequest is the ability to make a gift to loved ones or charities, but have the ability to retain and enjoy assets during your lifetime. Now, although it is an important process and one that should be reviewed over time, it doesn't have to be overly complicated. We are here to make it as smooth and easy as possible for you. So please utilize resources that we can obtain from our alma mater, like the Free Wills Guides that they provide. It's a great tool for gathering and organizing your information before meeting with your attorney, and even asking questions, right? We will let you know if we have an answer for you, and if we don't, we can usually find one. And then once your plan is in place, ensure you keep your documents in a centralized location to make the future process smooth for your loved ones. And so with thinking of your plans that you will put in place, let's switch gears to some opportunities or gift ideas that you could take advantage of because of recent legislative changes. So I'm going to turn it over to Greg to discuss those.
Thank you so much, Kinna, and thank you so much to the ECU Medical and Health Sciences Foundation for assembling this group tonight and for your time. I know how valuable it is. just want to say, you know, the Brody School of Medicine, the School of Dental Medicine, Allied Health, and our College of Nursing, they are paramount in the success of this region. And the things that they do for our state healthcare, they really are a shining beacon of aligning our mission of student success, public service, and regional transformation. And that's why I think it's so important to share these ideas that many people maybe have not thought of, because the work we're doing makes that much of a difference and it changes lives. So thank you for letting us share some of that information with you this evening. The thing we wanted to showcase initially is the Secure Act, and everything has an acronym within the government and in terms of legislation, and that stands for Setting Every Community Up for Retirement Enhancement. And there were 3 or 4 provisions in 2019 that came out of this act that I think are important for people to know. Number 1, the RMD, the required minimum distribution, was enabled to be moved back until 72 versus 70 and a half. You could continue earning, if you were earning income, you could continue funding your IRA permanently as long as you are an income earner, which was a change. And they were still going to allow you, while the RMD was moved back to 72, you could still use qualified charitable distributions at the age of 70 and a half up to $100,000. And then the final point, and the one we really wanted to point out, was that there was an elimination of the so-called stretch IRA, and it limits the amount of time someone can utilize this tool. The limits on the availability of the stretch IRA certainly hurt or impacted people, because this has been very popular. It's tax advantageous, and it allows you to generate and realize income that is untaxed until pulled out of the plan. So that's a huge benefit until your withdrawal. It's common practice for many parents who want to leave assets to children and grandchildren to use this stretch option, because it does enable them to take those payments throughout their lifetime. That, however, has been significantly changed based on this provision. The Secure Act significantly limits now who can stretch payments from an inherited IRA over their life expectancy. There are 4 categories, essentially. A spouse can still do so, a non-spouse who's less than 10 years younger than the deceased owner, a minor child of the deceased owner, or someone who is chronically ill or disabled. Any other inheritor of an IRA, however, has to take it within that maximum 10-year period that has now been placed with this Secure Act. Why is this important to know? The reason is there's a huge transfer of wealth that will be coming over the next several years in the U.S. Their IRS statistics say that there is over $8 trillion in assets held in traditional IRAs. Therefore, the inheritor pays income tax on the withdrawals at their marginal income tax rate, and thus will be a big taxable event by shrinking and narrowing that window. There are 3 possible charitable solutions that can help perhaps a person that has interest in being philanthropic, as well as stretching out payments to their loved ones. The first is an outright beneficiary designation. And I've provided an example here of Dr. Smith, who had planned on leaving $1 million to her favorite charity. And we all know that's the East Carolina University Medical and Health Sciences Foundation. And so with that, she had done some planning. She doesn't have an estate that is over the estate tax exemption, currently at $11.7 million for an individual. So she strategically decided to leave the best asset possible to charity and gift the other ones that were best to her family to maximize results. And so she made the ECU Medical and Health Sciences Foundation beneficiary of her $1 million IRA. And by doing so, she saved as much as $370,000 in income tax for her children when they withdrew that plan, if they were in the highest marginal income tax rate. So that is an example of how an outright gift, if you're going to give anything away, these IRAs and qualified retirement plans are a great asset to do so with. Actually, today, Missy Fallon with our Brody School of Medicine actually got a beneficiary designation completed, and it was for a percentage of someone's estate that's going to make a huge impact on a couple of funds for our Brody School of Medicine. You can do this very simply by selecting a percentage. It's not an all or nothing endeavor. You could do a percentage, a share, just like you would with your children, or a specific dollar amount that would make a huge impact down the line. So let's say giving the whole plan away or giving it outright isn't something that you necessarily want to consider. There's some other options and a couple of vehicles that can help you stretch out your payments while benefiting charity. A charitable remainder Unitrust is a great example of this. In this example, rather than leaving the $1 million from her IRA to charity outright, Dr. Smith decided that she would do a 5% charitable remainder Unitrust to benefit her two children who were 62 and 60 years old in this example. The beauty of this gift is you have to remember, you're not giving the full $1 million away. It's a part gift and part revenue stream. And so in the box, you'll notice there's an estate tax deduction of $282,840 that is the part of the charitable portion of that gift that would help the estate. Income taxes saved at a 37% marginal income tax rate would be $370,000. The after-tax benefit to children would be over almost $1.3 million, and the remainder to charity would be near $2.3 million at the end of the lives of both children. We have very in-depth calculations that we can run. We can do examples of all of this if you have interest in learning about that. So please feel free to contact our office and we can share some more of this information. The next gift that might work in a similar format is something called a charitable gift annuity. And it is a more conservative approach, and it does annuitize payments. And there are some differences that I'll discuss afterwards between the charitable gift annuity and the charitable remainder trust. But in the same scenario, Dr. Smith would rather leave the $1 million in a charitable gift annuity where her two children, 62 and 60, for the rest of their actuarial expectancy of 28 years. And even beyond that, if they live beyond the actuarial, the payments continue coming, but they would get payment for the rest of their lives. Again, the estate tax deduction would be over in excess of $176,000. It is a split interest gift, so only the charitable portion would be deductible toward the estate. The income tax saved at the highest marginal income tax rate would be $370,000. After-tax benefit to children is over $1 million, and the remainder to charity, $2.4 million. And so this is a great scenario where family can stretch out payments, family can benefit, but a charity can have a sizable amount of money to do the mission work of the organization. There are a few differences that I referenced in the charitable remainder trust and charitable gift annuity that I'll just explain, and why one might pick one over the other. The first would be funding amount. Charitable gift annuities can normally come in at a lower price point than a charitable remainder trust. At ECU, a minimum of $10,000 is the amount that we would start looking at charitable gift annuities. For charitable remainder trusts, we look at a $50,000 minimum to begin thinking that this might be the right vehicle for this type of gift. The number of payment beneficiaries is also something that differs. If you have a gift annuity, it can only be for 1 or 2 lives, and a CRT can have any number of beneficiaries. If your donor is interested in a gift plan that can provide payments for 3 or more beneficiaries, and you're interested in funding in amounts of sufficient size, you know immediately that the charitable remainder trust is the better option. A couple of other differences are that there is control when you set up a charitable remainder trust versus a charitable gift annuity. The gift annuities have assets transferred to charity, and we have an investment strategy set up for those types of funds. The charitable remainder trust, however, gives the donor the ability at times to possibly select a trustee or have input with the trusted advisor on the investment strategy that might move forward. Also, several of the larger companies like we work with, the North Carolina Gift Planning LLC, have a very tried and true blend of financial options and investment options that show the best outcomes that are also available for donors. The final thing would be that if you want to benefit more than one charity, the Charitable Remainder Trust is a better option that's available than the Charitable Gift Annuity, unless you want to do multiple contracts. The Charitable Gift Annuity is a simple 2-page contract between the institution and the donor and only benefits one area. The Charitable Remainder Trust can benefit your church, the Humane Society, your favorite educational institution, of course, the ECU Medical and Health Sciences Foundation, and there's a lot of flexibility on the number of beneficiaries that can benefit from your generosity from that one vehicle. So those are a few things that our legislative changes have made some new charitable options that might be desirable. And again, we can provide detailed analysis and some very nice illustrations for you to consider and share with your professional advisors if you're interested in learning about these approaches. And also, there have been some other great opportunities during low interest rate times that Kinna is going to elaborate on as well.
Awesome. Thank you so much, Greg. Just trying to make sure we had our slides right. So thank you for that and some great ideas, great opportunities. And so continue with some additionals, right? So first, we want to just point out that the unexpected onslaught of COVID-19 has produced many responses, including the Federal Reserve reducing interest rates to historic lows. One key interest rate, known as the IRS discount rate, directly affects the deduction value of certain types of charitable gifts. The last time this rate approached current levels was in August 2012, when it dropped to 1% due to the lingering effects of the Great Recession. And so the low IRS discount rate creates a unique opportunity with certain charitable gifts like your retained life estates, charitable lead trust, and even in some instances, charitable gift annuities. These are gift vehicles that you can think about when putting your estate plan in place. So for example, when we look at discount rates this year, they've been as low as 0.6% in January and February. And even currently now in April, the discount rate is at 1% like it was back in 2012. With the discount rate so low in relation to market interest rates, many donors have taken advantage of the phenomenon to pass significant wealth to charity and their family at a highly discounted transfer tax cost. And so we'll spend a little time on those retained life estates and more specifically charitable lead annuity trust. So there are several types of charitable lead trust, whether annuity, Unitrust, grantor, non-grantor. And any of these allow for transfer of assets from the donor to a trust. Those assets are then invested, and then the trust pays a charity for a term of years, measured either by the person's life or most often a specific number of years, after which the assets either go to loved ones or are returned to the donor, which is we call the grantor. A charitable lead annuity trust, which we like to say call a CLAT, is especially attractive to donors when interest rates are low because it requires a lower annual payout from the CLAT to charity to produce the desired tax deduction for the donor. With a non-grantor CLAT, this translates into more assets left to loved ones when the CLAT term ends. When the grantor CLAT, with a grantor CLAT, this translates into a higher principal value returned to the donor at the end of the CLAT's term, the most common being that non-grantor CLAT because you're benefiting your charity and your loved ones. And the next is the retained life estate. This can be in a primary residence, vacation home, or a farm, for example. With the retained life estate, a donor is able to create a gift by transferring title of real property to a charity while receiving a tax deduction for the value of that property minus that life estate or term of years value that was retained. The donor or life tenant named by the donor continues to enjoy the property for life or for a specific number of years. And this can be very advantageous because, of course, in times of low interest, it produces a higher current income tax deduction for the donors, while also allowing them, of course, to, enjoy that property for their life or for that term of years. And also still, of course, benefiting that charity of choice. So with that said, we definitely want to make sure that we point out resources that are available. I know we've provided a lot of information tonight, and so we want to make sure that we always recommend that you speak with your financial or your tax advisor, and also understand that ECU's Charitable Giving Office can provide resources and assistance, whether it's with their Free Wills Guide, or reviewing gift options or answering some of your questions. We also can provide, as Greg mentioned, gift illustrations from plan giving software. We also can provide requirements and policies around these types of gifts. And we also have access to TIAA Caspic as a resource, who is our investment management and gift administration firm for some of our life income gifts, like those charitable remainder trusts and charitable gift annuities that Greg mentioned. And so that completes our presentation, and I will turn it over to Dr. Garrison for our question and answer session.
Thank you so much, Kinna and Greg. That was wonderful. A lot of information, and I've got a lot of questions, and I would encourage people to put a question in the chat, and if you don't have one, then or if you have one and you just want to ask it out loud like I'm going to, feel free to raise your hand. And Natasha, if you'll let me know if someone's hand goes up and I don't see it, but I'm going to start, and while we have these experts here, pick their brains. So Kinna, tell me what happens from a legal standpoint when you die intestate. Let's say you got 5 children and they don't love each other 100%. What happens, and let's say both parents die at the same time and they didn't have a will. What's the legal process?
So of course, when you die without a will or a estate, even in North Carolina and most states, they have what is called intestate succession rules that they have to follow when distributing your property, your estate. And so, in North Carolina, we go by, I think, per stirpes. And everybody's like, what is that? But basically in North Carolina, state decides where your estate goes, and it's going to be based on what living relatives or heirs you have left. And so in that instance, it could be a situation where, like you said, children don't get along, and they're having to deal with the state saying, well, this is the percentage of your mother or father's estate that you're receiving. And so it can cause a lot of disruption between family members. And, there may be specific things that you want to go to a specific child, and that won't be the case. It will be divided equally among all of them.
And the lawyers have to be hired, and is that a good?
So the other thing
is it for the family? And let's say they don't like each other. Do fights result and stuff?
Oh yeah, it can definitely, as I mentioned in our presentation, it can cause a lot of confusion, especially when you're looking at, how that estate is distributed. And if certain individuals are not getting along, then you get other attorneys involved, because if you don't have an attorney or an executor of that estate, then those children that may not be getting along will have, may have attorneys of their own, and that can cause some issues, especially going through the process of distributing the estate. You don't want those issues by no means.
No.
And you don't want the issues that can arise amongst your family members, especially during a time of a loss of a loved one.
Just makes a bad situation worse.
Absolutely.
So Jessica Emick, thanks for joining us tonight, and has a great question for the donor. This would be from the perspective of the donor, as far as benefits for them as well as the charity. And this was one of my questions. What's your suggestion for the most effective and easiest plan giving vehicle? Greg, you want to start with?
Yeah, I'll take a stab at that, and Kinna can add to it as well. I think it's interesting because each individual has their own objectives that they're trying to satisfy. But I think my general answer would be the two that work for most people, regardless of situation, are the bequest provision because of its simplicity, the fact that it enables you to keep assets. We none know what our age is going to be when we die. We also don't know what healthcare expenses and taxes are going to look like in that time frame. So a lot of people prefer to make the commitment of a revocable gift, but hold those assets in case they need long-term care, in case there's a family situation. And so it gives them a great deal of flexibility. Now, when donors do that gift for us, we do a lot of something called a blended gift. And so they say, we're going to put this aside. This is significant, and we want this major impact on our Medical and Health Sciences Foundation, but we want to fund it annually so we get to enjoy it while we're living. As a matter of fact, Dr. Garrison just worked on a gift like this not too long ago, where we have a donor that's got his whole family involved in the process, and they're going to annually recognize a student and enjoy their philanthropy while living. They may increase it. They've already had thoughts and talks of increasing it during time. And then they know ultimately there'll be a remainder amount that will establish an endowment that will give them a perpetual legacy at the university and at the Medical and Health Sciences Foundation. So that, as well as the IRA beneficiary designation, are the two, because again, you do miss on the withdrawal tax from whoever the heir is. That is probably the top asset to give away, and it can't be given either until death. And so you can use it during your lifetime. And one thing people do with that is that after 70, many people who are giving us a portion of their IRA begin to self-fund with that vehicle as well, because they can use their RMDs or up to $100,000 to enjoy it during their lifetime as well. So plan giving isn't necessarily an all end of life gift. It can be very much enjoyed currently.
Absolutely. And I'll just add to that, Greg. So those would be the first two that I would always point out. They're usually the most effective and easiest plan giving vehicle to put in place. But I also like to point out the life insurance, right? So especially like Greg said, it's based on your goals and where you are in life. You know, I like to think of myself as a young alum, right? My plan gift was, a percentage of my life insurance policy. I don't have a large estate yet, but that's also something that's easy to put in place. And like I always like to say, bequests, the beneficiary designations, as well as life insurance are some of those plan gift vehicles that you can kind of set it and forget it, right? So you put it in place and then it's there. You don't have to worry about it. And then you can continue to work, think about, what you might want to do during your lifetime as well. So, and it's one of the easiest. So I would say those three would probably be the easiest plan gifts to put in place. And then I did see that Jessica had a follow-up that asked, bequests are revocable, correct? And so to answer that, yes, bequests are, as well as your beneficiary designations and those life insurance beneficiary designations as well.
Just could you go a little deeper on revocability? Kinna, like, what does that mean exactly? And when does it come into play? Is it a good thing or a bad thing? Do most people choose it? How does that work?
Yeah, absolutely. So revocable means that a gift, it can be taken away, right? So when we speak about irrevocable and revocable, we're looking at the ability to, it's permanent versus it's something that can be changed. And so with revocable bequests, those beneficiary designations, they can be changed throughout time. Whereas something like a charitable remainder trust is something that once it's put in place, most of the time, the language in those trusts are written where they are irrevocable. So meaning that they can't. And Greg,
and I would say as a general rule of thumb, if you are worried about having enough assets to make it through your lifetime, I think the revocable is a way that gives people much greater comfort. Most times, statistically, however, we have found that what they intend to give and what comes is normally a greater amount actually comes than they had, if they do a percentage, than they had actually even thought. The irrevocable can be wonderful because it does give you some current income tax deduction, which can be part of your strategy, as well as help you distribute assets in some ways to heirs. So again, we can find the right vehicle depending on your personal situation.
So Glenn has a great question about interest rates. If you choose a vehicle with an interest rates that are low, and then rates go up or the market changes, talk about all that.
I'll start, and Kinna, you can kick in obviously as well. So that's a great question, and something I didn't get too deep into the weeds on when we talked about charitable gift annuities and charitable remainder trusts. Charitable gift annuities are set, the rates are set by the National Association of Charitable Gift Annuities. And so that is a hedge. It can be a hedge. Whatever the rate is based on your life expectancy, and it will not deviate whether rates go up or down. And so right now, fixed interest rates are like 1% or lower for many CDs and things of that nature. These rates, depending on your age, it's say 60 and older, start at 3-4% and upwards. And as you get older, they climb. And regardless of market volatility, you will get that annuitized payout. So it can become a great hedge against inflation. Charitable remainder trusts have two options, one of which is an annuitized rate, which typically appeals to folks that are a little older. And the other is a Unitrust rate that does ride the ebb and flows of a market. And typically younger people have a tolerance for that and will probably make out better in the long term by having that flexibility. But each of those products gives you some options as to what you're, again, the end benefit, if you're looking for security and annuitized payments, or whether you're wanting to ride the flow of the market. Kinna, please add.
Absolutely. And I'll just add to that, you know, when thinking about the interest rate, you're thinking about the deduction at the time that you create the gift versus some of those life income gifts. Those are going to, the rate of which your payments are going to be slightly different. So I'll just point that out.
So Kinna, talk about the difference between a will and an estate plan. Is one part of the other or vice versa? And then how important is it to have an attorney? Can you do this without an attorney? These things seem like they could be complex, but what if your estate's relatively simple?
Yeah, so the first part of your question, I always like to think an estate plan can encompass a will, right? Some people may put a will in place, some may put a living trust in place. It just depends on that person. But I think in essence, you want to have some type of plan in place, whether it includes a will or a trust. As far as if you should have an attorney, I would recommend that because you want to make sure that your will is adhering to state requirements for that will. So that way, if you pass away, you don't want that will to be to have any issues when it comes to the requirements of the state law, right? So because then there may be issues where it's contested, and so you want to make sure that you know you're meeting all the requirements required by state law, and then you also want to make sure you have that advisor to kind of point you in the right direction of what may be best for the type of estate that you have or the assets that you have. Will may be best or a trust may be best. It depends on what your goals are. So I would advise always to have one. But if you have a smaller estate and you don't feel that you need to have one, there are you know, other services that you can utilize to just do a simple will, whether it's online services or things of that nature. But usually I would recommend an attorney just because they will know the state law requirements for wills in North Carolina, as well as, you know, just helping you figure out what's best to put into your estate plan. So for mine, for example, my estate plan, I have a living trust that I've put in place, but I have a will as a backup document. So if there's anything that I did not put into my trust during my lifetime, that will clarifies that any assets, I want them to be funneled into that trust. So it's a great way to, like I said before, pointing out what you want and where you want your estate to go.
So Elizabeth has another great question. And I think we could ask this question about either the lawyer or the executor. So what happens if you outlive your lawyer or your executor? Should you have a backup plan in your estate plan for that circumstance?
Absolutely. I recommend always having a backup plan and always, especially if you have a backup as far as who's going to be your executor, having a copy with them, but also letting, I have one of my loved ones is my kind of, okay, my plan is, this is where it, all of my documentation is. So that way someone knows what to look for and where to look for it at, right? That's the whole point of making sure you're keeping your documents organized. So that way it makes it a smooth process for your loved ones when they're trying to figure out, well, what was their plan? What do they want to happen?
I would also just, thank you. I would also just add that that it's usually appropriate every 5 to 10 years in the point, if your attorney dies, your life stages change. And so when children get older, when they go to college, when you then become an empty nester, all those things, there are multiple points where you should probably do a estate plan sort of update. And that would hopefully make you would be able to tell whether your attorney, if you needed to make some contingent plans with that as well.
And then I assume that that inverse correlation in that if all of your things are in order, you'll live longer. Is that true?
Statistically, actually, yes, it is.
Is it really?
Now,
I was just joking. Tell us about that.
Well, one would guess, just because people who have access socioeconomically to do that type of planning probably have better health care, better diet. So there's a correlation to a lot of factors, but I have read statistically, if you make an estate plan and have a charitable account, you do typically live long.
Jessica, you want to unmute and ask your question? Might as well get a little dialogue going.
I'm sorry. I was just wondering, what are the benefits of having a living will or a living trust versus an actual will? I know there are some differences as far as having to go through probate once the person passes away. What are the costs? Just some general questions of the differences between the two.
Definitely I can start, Greg, if you want to add anything. So the difference really is kind of their function, right? So a will is more directed for distribution of your assets when you pass away, and that does go through probate. And then you have the living will, which gives directions regarding like your medical care, as say if something was to happen during your lifetime and you're unable to communicate those wishes. And within that living will, packet, I would say there is a potential to have a durable power of attorney for like your healthcare directives as well. That answers your question. Greg, did anything?
Yeah, and I think you're exactly right. And you can also, there's multiple powers of attorney: durable healthcare, your financial, and so again, I think it's a series of things you want to have in place that will protect you.
Kinna, you said something about you want to have 100% of your estate accounted for. What would be the circumstance where let's say you do have an estate plan, what would be the circumstance where it's not 100%? What happens in that circumstance?
So of course, so anytime, let's say you have a plan in place and you have some specific bequests, you have some general bequests, and then whatever's left is considered your residuary, residuary of your estate. And so if you don't give away all of that residuary, then it's kind of like you haven't designated in your will where it goes. And so then therein lies the confusion, because that part is not a part of your will. So then that process will have to go through the courts as well. So again, you're not getting to select the distribution of those assets and where they are going. And like we mentioned earlier, there goes the confusion between family, and that can cause problems as well if you haven't designated where that percentage of your estate is going.
So it's sort of like dying intestate for that part of your will.
Absolutely.
same problems. Jessica?
So question, so as far as a will versus a living will, which would distribute your assets quicker and which would be more efficient?
So I would say, so the will itself is what actually distributes your assets. And that does go through probate, and that can depend on the size of the estate as far as the timing. But the living will really directs the medical care of someone if they're still living.
Yeah, the way I think of a living will is if you become incapacitated and and your family needs direction, like, do you want to be on a ventilator? Do you want to have, it's sort of like it's advanced directives would be thought of sort of like a living will.
Right. So it doesn't distribute your assets. It's more so if this happened to me, you know, what would I prefer as far as hydration, nutrition, things of that nature. You see that more if someone's, you know, unfortunately in a vegetative state, that kicks in.
I think Jessica might be talking about a revocable living trust, perhaps, in terms of the ability to avoid probate and the ability of the will to pour over into that document. And there's some privacy and it does avoid some of the probate, I believe is what.
Yes, I think that's what she's talking about. So maybe
That's exactly right, Greg. I'm so sorry. Yes, that's exactly what I'm referring to. Thank you.
So in that instance, I think Greg mentioned then definitely if you're worried about privacy, a will is actually going to go through probate, public record with a couple like living will. If you have something pour over into like a trust, that does not go through probate. So it's not going to be public record and it can be a faster process.
All right. Does anybody have any final questions? I want to thank everyone who joined us for the webinar tonight. Thank you for giving us your attention. Once again, thanks to the behind the scenes work, Grace Tolson, Jessica Nottingham, Natasha Parrish, and Nicole Stokes, who I'm sure will watch this when she gets back from Las Vegas. And if you don't mind, I'm going to ask Greg and then Kinna to wrap us up, some last words of advice, and thank y'all so much. This is a great presentation.
Thank you. I very much thank everyone for their time this evening. I just reiterate that the work that is done, the importance of our Medical and Health Sciences Foundation, the work that our students at Brody School of Medicine, the School of Dental Medicine, Allied Health, and Nursing, we are such a key stakeholder in not only Eastern North Carolina, but the entire state. And that mission is so noble and so important. So we want to share every opportunity for people to have a chance to see that impact, to make a gift. And we will travel anywhere and meet anytime to discuss those options at low pressure and just providing you information to use with your advisors.
And then I'll just add to that, Greg, thank you all for joining us tonight. We hope that it's very valuable information for you all. If you have any follow-up questions, please feel free to reach out to Greg and team, myself. I am at the system office, but I am always available for my ECU family. So definitely let me know if you need anything from us. And I just encourage you to, review the information, and if you have any follow-ups, just to, how to get in touch with us. But thank you again for having me come back as well. This is definitely a very valuable subject, one that I'm very passionate about. So thank you all for your just thoughtfulness for our institution.
Thank you, Kinna, and thank you, Greg, and thank you all so much. A round of applause.